I'm going to speak briefly today about two cases that are coming up this term, and then one area of the law that I think is pretty likely to also be before the Supreme Court. So let me begin with one of the cases we can expect, and that's Fisher versus University of Texas at Austin. If this is a familiar name to some of you, that's because the Supreme Court has actually heard this case before. This is the case of Abigail Fisher, a white college applicant who sued the University of Texas at Austin because she claims that the school's race-conscious undergraduate admissions policies violated her right to equal treatment under the Equal Protection Clause of the 14th Amendment. UT uses race as what it calls a plus factor to ensure diversity on campus. October 2012, the Supreme Court had oral arguments in this case. 8 months later, in one of the great anticlimaxes of recent Supreme Court history, the court ruled 7-1 on the case, but essentially punted it back down to the lower courts. It went back to the lower courts. It's now back before the Supreme Court, so we're going to have the case this term. Now, to understand Fisher, I think it's important to talk a little bit about the prehistory of the Fisher case. And this begins really in 1996 with a case called Hopwood in the Fifth Circuit. So the University of Texas at Austin had a similar race-conscious affirmative action admissions program for undergraduates at the time, and the Fifth Circuit struck that down, said this was unconstitutional. A year later, 1997, the Texas legislature responds to the Hopwood decision by enacting something called the Top 10% Plan. This basically says that if you graduate in the top 10% of your class in one of the accredited high schools in the state of Texas, you're guaranteed admission into the University of Texas system. This was an attempt to create an ostensibly race-neutral means to ensure diversity, to ensure that underrepresented minorities are coming into campus. This is the legislature's attempt to grapple with the Hopwood decision. Now, around the same time this is happening, late 90s, early 2000s, two other affirmative action cases start bubbling up in the courts, these coming out of the University of Michigan. And in 2003, the University of Michigan's cases are decided by the Supreme Court. Gratz versus Bollinger, where the court struck down Michigan's use of race in undergraduate admissions, and Grutter versus Bollinger, where the court upheld Michigan's use of race in the law school as a plus factor. The court said that Michigan's law school's use of race was one modest factor among many in determining an applicant's admittance. The day that Grutter is handed down, the University of Texas announces that it is reinstating a race-conscious undergraduate admissions program to be consistent with Grutter. Before that, it had just been the top 10% plan had been what had been largely accountable for, or what had been largely been creating the racial diversity on campus. The university says that really hasn't been enough. It's not enough to ensure a, quote, critical mass of minority students on campus, and so the school brought race-conscious policies back. That creates the lawsuit, Fisher versus University of Texas, that Supreme Court has heard and is now hearing again. Now, when we're talking about the government's use of race, and when we're talking about the University of Texas, we're talking about the government. It's a state school. These are government employees who work there. When you're talking about the government's use of race, the government's use of race has to survive something that the courts call strict scrutiny. This is the most exacting form of judicial review. And strict scrutiny is a two-part test. It says that the government's use of race must serve a compelling state interest, and it also must, that's part one, and part two, it must be narrowly tailored to achieve that compelling interest. The Supreme Court has held for some time that ensuring diversity on campus is a compelling interest, so they can meet that prong. When Fisher 1, let's call it, was before the Supreme Court a couple years ago, when the court sent the case back down to the Fifth Circuit, it was because the Fifth Circuit had not really done a serious investigation into the second prong, the narrow tailoring prong of strict scrutiny. And what Justice Kennedy's opinion for the court said was that the Fifth Circuit had been too deferential, had taken the university's assertions that this is a narrowly tailored program on good faith, and that's not what strict scrutiny requires. It's a more meaningful examination, so the case is sent back down. The Fifth Circuit rules in favor of the university once again. Abigail Fisher appeals to the Supreme Court once again. Now the court is before us once again. I think at the very least we can say there's not going to be a punt this time around. I think the court will give us a ruling on the constitutional merits. I suspect that the University of Texas is not happy to be in this position a second time, that their program may be in some trouble. And one of the problems, let me just say, that the University of Texas faces is that the idea of narrowly tailoring a race-conscious program to meet a compelling state interest, when you're narrowly tailoring something to achieve critical mass. Critical mass is an undefined and difficult to define term, and the university resisted defining it during all arguments in 2012. So I think that's going to cause them some problems this time around. But this is affirmative action, this is race, this is going to be a big battle, something exciting happening at Supreme Court on this issue. The second case that I would like to talk about coming down the pipeline is a little less high profile, but also very important, and also has some very important implications for the law. This is a case called Luis versus United States. This case centers on the Sixth Amendment right to trial, also implicates the Fifth Amendment right to due process. Now, it is established in Supreme Court precedent that prosecutors may freeze the assets, Ilya referenced this in his opening statement, may freeze the assets, the tainted assets, of individuals who've been indicted for certain criminal acts. And the Supreme Court says this doesn't violate the Sixth Amendment, even if these individuals would like to use their tainted funds to pay for a lawyer. The classic example is the bank robber. I rob a bank, I am arrested, I am indicted for robbing a bank. I would like to use my ill-gotten gains to pay for the best criminal defense lawyer money can buy. I don't have a right to use other people's money to pay my lawyer. Fair enough. Well, what about non-tainted assets? What about legitimate assets, money that is not directly traceable back to the underlying crime that you've been charged with? Well, that is the question in this case. Ms. Louise, who is the central figure here, she was indicted in 2012 in Florida for being involved with operating this kind of complicated Medicare fraud scheme. That is, she's alleged to have defrauded Medicare of upwards of $40 million. Essentially, she's in the healthcare business, home healthcare business. There's a series of kickbacks to medical providers. There's falsified medical reports being sent to the government, overbilling, these sorts of things. This sort of allegedly happening. She's been indicted. This is all pre-trial. Allegedly, thank you. So the prosecutor in this case has moved successfully to freeze all of this woman's assets. And under 18 U.S.C. Section 1345, which is a federal forfeiture statute, such freezing of tainted assets may occur, or tainted assets or, quote, property of an equivalent value. So the government's argument here is that there's probable cause that this woman did this. She's been indicted. There's probable cause that we're going to convict her, and we would very much like to put a hold on this money because she's on the hook for $40 million if she's convicted, and this is forfeitable money, and we would like to make sure she doesn't dissipate all these funds by spending it on her lawyer or other things. And she has about $15 million of non-tainted assets. This is money that's come in through non-Medicare channels in her business, and she would like to use that money to pay for her lawyer, and she says she has a Sixth Amendment right to do so, as well as Fifth Amendment right due process. So this case obviously is being watched very closely by the criminal defense bar. There are major implications for criminal law. There's property rights elements. So this is an important and interesting case. It may not get as many headlines as Fisher, but it's also definitely one to watch in the coming term. So those are two cases that are happening for sure. And now, and also just in case, Medicare fraud and affirmative action aren't exciting enough for you, we can talk about abortion, which is another issue that may well end up before the court this term. There are a few petitions before the court right now. There's some cases in the pipeline. And I think it's likely that a major abortion case will be before the Supreme Court sometime this year, maybe this term, maybe the next term. And so I thought I'd talk briefly about two of the cases that are before the court now in petitions for cert. And you probably heard about these, and these could be the kind of cases that are taken. They share some interesting similarities. They're both out of the Fifth Circuit. They're both dealing with state regulations on abortion been passed in the last few years, regulations on physicians who perform abortions and the clinics where the abortions occur. And these are ostensibly health and safety regulations. But there's a question if that's their purpose, if that's their effect, or maybe they're an undue burden on abortion, to use the Supreme Court's language. One of these cases is from Mississippi. It's called Courier versus Jackson Women's Health Organization. And it turns out the Jackson Women's Health Organization of Mississippi is the one and only abortion clinic in the entire state. And the Fifth Circuit has struck down the abortion restrictions in this case, and the state has appealed, and that appeal is pending before the Supreme Court. And the second case, also from the Fifth Circuit out of Texas, Whole Women's Health versus Cole. In this case, the Fifth Circuit has upheld the state regulations, and if these go into effect, they could close something like 75% of the clinics in the state. As I said, both these are pending at the Supreme Court. There are other abortion cases in the pipeline, but so there's a potential of a term where we have things like affirmative action, abortion, really boring issues that don't interest anybody, and reporters have no interest in either. And just to conclude, I wanted to say a few words about Chief Justice John Roberts, just kind of maybe a big picture kind of talk about the Chief. I don't know how many of you endured last night's 3-hour-plus Republican presidential debate. Hands, so don't brag about it. I'm paid to watch that. Well, you probably noticed a segment where Chief Justice Roberts was criticized quite severely by Senator Cruz and others, and this has been sort of a common theme on the right in the last few years. I've seen the Chief Justice referred to as a traitor to legal conservatism. He's betrayed legal conservatism. He's even been compared to Justice David Souter, which frankly that's a kind of a low blow even for the Chief. These attacks are all, of course, about Obamacare, about the 2012 decision by the Chief Justice where he saves Obamacare from a constitutional challenge, and then they're also about, the case we heard about today, more recent, a statutory challenge to Obamacare, which the Chief also saved the law from destruction. So I just wanted to end by challenging the idea that Roberts has betrayed legal conservatism. I think if you look at legal conservatism, the conservative legal movement over the last, let's say 40 years, you see that legal conservatives have repeatedly championed and embraced the idea of judicial restraint or judicial deference, that the courts are the least democratic branch of government, therefore they owe extra respect, more deference to the elected branches of government, to the president elected, Congress elected, state legislatures elected. And John Roberts in his Obamacare decisions, especially 2012, but also I would argue this more recent term, has really embraced the concept of judicial deference. I think that he stands for conservative judicial restraint in many respects. In 2012, in the Obamacare case, he wrote, quote, "It is not our job to protect the people from the consequences of their political choices." I think that's sort of the classic argument for judicial restraint, for conservative judicial restraint, which is an argument conservatives have been making, as I said, for the last 40 years from Robert Bork on down. And so I think that the current conservative disenchantment, disgruntlement attacks on Roberts tell us something very interesting about where the conservative legal movement is right now, where legal conservatives are, which is that these arguments for judicial restraint and for deferring to the will of the majority, deferring to the representatives of the people, they don't quite carry the same weight that they once did. And there's a lot of factors, I think, that have changed, that are changing this attitude on the right. One, I think, is what I call the libertarian legal movement. Libertarian lawyers, legal scholars, activists, people here at the Cato Institute are centrally involved in that, as well as the rise of originalism, constitutional originalism, which, if you think about it, the idea that the court should defer to the elected branches of government and the idea that the court should be upholding the text of the Constitution even when 51% of the people don't like it, these two concepts they're sort of at war with each other. They certainly don't coexist easily. And so we're seeing I think, legal conservatives grappling with these two ideas, and I think that that's something that is well worth watching and is going to continue to be something that will be happening on the Supreme Court in the years to come.